All right. Court of Appeal, and what's the day of court is now in session. Ryan, hearing Alan Martella, judge, presiding. All persons present for the court, for all hearings, and attention to will be heard. And God save the United States of America, the state of Florida, and honorable court. Please begin.
Good morning and welcome to an oral argument session of the 6th District Court of Appeal. Our session today will be live streamed, so please keep that in mind. We have two cases for our consideration today. Each side will be allotted 20 minutes. The first case that we're going to call up today is the estate of Renato Pileski versus Ann Birnbaum individually and as trustee of the Birnbaum Family Trust, and that's case number 23-198. Counsel, we have set our clock to give you 5 minutes of rebuttal. Would you like a different amount of time?
Perfect.
Counsel, when you're ready, you may proceed.
Morning. May it please the court. My name is Giacomo Bossi on behalf of the estate. There's two distinct bases today as to why the decision of the lower court should be reversed. The first one is that the decision the property was Homestead was premature. We needed additional discovery, and we did not get a chance to obtain that discovery. The second one, certainly the more interesting one, is that the determination of Homestead is not dispositive of this case because the question of damages is left open.
Let's talk about the first one first. Got two questions. So you're combining your second two issues for appeal basically in the first for purposes of today. You've got the discovery issue and you've got the amendment issue. So let's start with the discovery issue. You'll agree with me this is an abuse of discretion standard, correct?
Correct.
So we're looking at the context. You're arguing that no reasonable trial judge should have gone forward with this summary judgment case.
Not just that, Your Honor, I argue that under the new standard, the lower court was required to provide this court and my client with an explanation as to why the court decided that no additional discovery was needed. But even under that standard, I want to give you my theory as to why Homestead is different than other things. In a normal case, I argue against another party, and so I have access to some information because I'm making a claim. Homestead is uniquely a defense, and that defense rests uniquely in the control of the defendant. They had the intent to move in, they had the ability to change the documents, they have the ability to obtain the driver license. It is unique in this sense because the plaintiff, in this case, the estate of a foreign individual, has no independent knowledge of what a defendant has or has not done. And
do we look at as well, I understand that, and that makes sense. Do we look as well, though, at what you'd actually done to obtain the discovery, and also the likelihood of success of getting that particular discovery? You had filed one motion to compel, and this is what I'm getting at. You filed one motion to compel. And in your brief, you take issue with the interrogatory responses and the responses to the request for production. You filed one motion to compel. So this is what you've done between the time that the homeowner and the trust had moved for summary judgment and when you responded. Your one motion to compel sought the production of a financial affidavit that you would not have otherwise been entitled to until you got a judgment. Fair?
Fair.
Now, maybe in that Miami-Dade action, you could get that relief now that you've domesticated that judgment. However, what power did the court have to give you something that you had no power to get under the rules of civil procedure? It's a loaded question.
I understand. I think I had the power to obtain the additional discovery, including the utilities bill that we had requested, which were objected to. And so
but you didn't move to ask for that is what I'm getting at. So when I look at whether there's an abuse of discretion, and maybe this more focuses my first question, when you had not asked for that additional discovery in any way or moved to compel it in any way, how did the trial court abuse its discretion by not continuing the hearing or allowing you to get that discovery?
I understand. I had moved to compel the financial discovery, which in turn would have also potentially revealed financial information as to how the money that was obtained from a forged will was spent. And if some of that money was spent within the homestead that was already established, for example, for renovation, to reduce the amount of a lien, et cetera, an equitable lien could have been established. But I certainly understand, and I agree with this court, that this court is entitled to look at what was done in the lower case in terms of deciding that abuse of discretion standard. That the answer to that question is yes, Your Honor, you are certainly entitled to do that. I have no case law to say that you're not entitled to do that. I want to point out that in this particular case, because there was also a parallel action in Miami for the recognition of the judgment on which there was an objection, there was a little bit of a time challenge, because until I was certain that my judgment was going to be recognized in Florida, I wasn't really certain of the finality of my position as a creditor. And so to a certain extent, it did make sense to wait to be sure that we were creditors before fully expand on a fraudulent transfer.
I get that, but let me ask about the motion for leave to amend. I don't see anywhere that that was ruled on. If it's not ruled on, how is it before us? How can we say that the trial court erred if we never actually had an order denying that request? And I know there's no transcripts. Maybe it was done orally at the summary judgment proceeding, but we don't know that as an appellate court because it's not in front of us.
So I think that's exactly the problem. The problem is the motion is in the docket. Therefore, the court below has notice of the motion. And yet the court enters an order saying the case is over without ruling on the motion for leave to amend, which is in the docket.
But how do we know that you ever brought it to the court's attention?
I believe that the motion for rehearing, which was filed before the final order was actually entered, brought that to the court's attention because it brought the difference and the distinction between the idea of the idea that the termination of Homestead does not complete the case, and in fact, there's also a pending motion. I believe that it does that, and again, that's even before the lower court enters the written order on the summary judgment. But I don't think that I have to bring it to the court's attention to the extent that it's in the docket. I believe that the law is that once the motion to amend is in the docket, even though I understand there is no transcript from the proceeding below, the court is on notice and knows that there is a pending motion for leave to amend and cannot close the case without ruling on that motion. I believe that that's the law on this
As a
point.
former trial judge, I will tell you that those civil judges have 3,000 civil cases in their division. They are not sitting there looking to see what's in their docket. That's why in the state, as opposed to the federal court, it's your obligation as an attorney to call up what you want to have heard. So I can't tell, I guess what I'm saying, and I'll look at the motion for rehearing argument. I think it might have some merit, but I don't think that we can just look at the entire docket and assume that the trial court knew about it.
Counsel, I want to talk a little bit, if I may, about the heart of your action. You brought a fraudulent transfer action. You brought it against two defendants. You brought it against Ms. Birnbaum individually, and you brought it against her in her capacity as trustee of her family trust. I cannot tell, so I'm looking for you to elucidate this for me. What is your theory as to Ms. Birnbaum as an individual? Is she being sued as transferee or as transferor?
Both. And thank you for this question, Your Honor, because there are two transfers in this case, not one. When we filed the action, Ms. Pocci has transferred the property only from herself personally to the trust. In the pendency of the action, she transfers it back to herself, flies down from Ohio, moves in, and claims Homestead. It's two transfers. So Ms. Pocci is both the transferor in the first transfer and the transferee in the second transfer.
And I understand that, but are you saying that she has liability under the act as transferor, or are you saying that she has liability under the act as a subsequent transferee?
Both. What I'm not saying is that I'm not entitled to double damages, but if it were just one transfer, let's say the first one, she will be liable as the transferor who has taken out the property and caused damages to my client by taking it out. The 726 fraudulent transfer statute is clear. You get damages against the transferor and the transferee up to the value of the property or the difference if you've been able to obtain something, and that something is equitable in terms of what you were entitled to. So the first time, she is liable as the transferor. The second time, she's liable as the transferee, the party who allowed the transferor to take the property out of their assets.
Can you point me specifically where she's liable as a transferor subsection?
Yes, I believe that 729.02, I'm sorry, 729-109-02. I'll pull it up.
Well, 09 is transferee liability. 08 talks about transferor liability.
No, you're correct. The 109 only talks about the first transferee and any subsequent transferee, right? So that liability expressly is only established as to the transferee under 109. But I believe that under 108, and if you look at the Pasternak case that we also cited in the Middle District, the party who has facilitated the transfer, that defendant, is equally liable, and 108 states any other relief that the circumstances may require. So to the extent that I prove that she has transferred the property the first time outside of her assets, and by doing that, the transfer was voidable, then she is liable because it is a fraudulent transfer. And if what the relief that I have is monetary, that I'm certainly entitled to that monetary relief, also against the transferor who is participating just the same as the transferee. What I think the key is that is jointly and severally. I don't think I get the money twice. If I then eventually recover from the transferee the money, then that will extinguish the transferor judgment. If I get it from the transferor, it will extinguish the transferee judgment because they originate from the same act.
I want to go down that line a little bit. As transferee, can you be liable as both a subsequent transferee and a transferor? Because what happened here, as you've mentioned, is it was given away and then it was given back. So in some ways, there's no need to void it because the asset is where it originally started.
So first, the answer is, in general, to the statement, yes, you can be liable both, because if you have done two transfers, you can certainly be liable for the two transfers. What's important, Judge, is that if the occurrence of the transfer is what delays the ability, hinders the ability of the creditor to obtain the property. But not because eventually, after a long cycle, you bring it back, because now, at the time you bring it back, it's more convenient to you as the original transferor, then you have undone your evil. The fact that you have, by transferring constantly, hindered the ability of my client to go get it is exactly what causes my damages, and is exactly what we would have been entitled to show in the lower court.
What would your relief in this instance be against the transfer?
The value of the property.
But you've already gotten judgment against the transfer for an amount that is greater than the value of the property.
That would be on top. It would add on the original, because when I got the judgment, that is from the original Italian action. Then I've been damaged in my inability to obtain the value of the property by the transferor transferring that out. But again, there was no discussion of damages because the court below didn't have any discussion as to why Homestead made the action go away. No ruling, no discussion, and in fact, Ms. Pocci, in the original motion for summary judgment, doesn't do that. The only place in which in the motion for summary judgment below, Ms. Pocci says, because it's Homestead, then it goes away, it's in the word for clause, with no explanation, no support. And then the lower court says, because it's Homestead, it goes away. No explanation, no support.
Well, let's assume for the sake that you're right, my question that you're right, and that this was premature as it relates to Ms. Birnbaum, who I guess we've been interchangeably referring to as Ms. Pocci, but I think she's been going by Ms. Birnbaum for 50 plus years. So as it relates to Ms. Birnbaum, maybe the trial court leapt to the end, but explain to me when the only thing that we're challenging in the complaint is the change of the property, and the property has been decided by the lower court to be her homestead. You don't challenge that determination on appeal, maybe because you can't, but you don't. How isn't that, if it's error, how isn't it harmless error? How could you possibly get anything from Ms. Birnbaum based on it being her homestead? I mean, the Habaco case specifically talks about how the Florida legislature can't pass something that defies the Florida Constitution. The Florida Supreme Court has said that our Constitution has homestead protections, even if people transfer property to delay, hinder, or defraud creditors. So as it relates to Ms. Birnbaum alone, even if the court left to the end, how can we reverse that?
So I believe that the 11th Circuit Court of Appeal And Your Honor, I apologize if I don't have enough time to answer you. I'll do it on my rebuttal. The 11th Circuit Court of Appeal in Doling versus David in 2008 answers exactly that question. Exactly. And it answers it in favor of the estate, or what would be the estate, meaning in my favor, they say the fact that you cannot go get the property back does not defy the fact that the transfer at the time it occurred was voidable. Because the transfer was voidable at the time that it occurred, that's all you need under the statute, under a textual interpretation of the statute, that's all you need, and therefore you get damages against transferor and transferee. They answer exactly this question. It is the only case, in addition to the Middle District in 2019, that admittedly applies Davis because they're required to. It's the only case that has decided this issue. It is not binding on this court. It's only persuasive, but they go exactly through the analysis, which is exactly the analysis that we have made, and they say the termination of Homestead prevents you from obtaining the property. You can't sell it. And importantly, I have 5 seconds. Homestead may change. Today may be Homestead. What if it's no longer Homestead in 6 months from now because she moves out? Do I re-get my action? Of course I don't re-get my action. I already have my action now. I'm able to get damages, and if it's no longer Homestead, I'll just be able to execute on that property. Homestead changes over time. I'm over my time. I'll be back. Thank you.
May it please the court. Good morning. My name is Stanley Bunner. I'm here on behalf of Ms. Birnbaum. Ms. Birnbaum urges this court respectfully to affirm the order granting the motion for final summary judgment. I look at this case as like a walnut. There are some odd procedural issues surrounding it, a hard shell that we'll get through, but the meat of the case is Homestead. And Your Honor got to that point exactly. The fact of the matter is, my motion for summary judgment is clear. The order is clear. The transfer cannot be avoided because of Homestead protection. And when you cannot avoid the transfer, you cannot get monetary damages against the transferee.
But counsel, at the time the transfer was made, it has not been established that it was Homestead yet. The Homestead was not established until after the transfer was made. Is that not right?
No, that is correct, Your Honor. In fact, I don't think there's anything to suggest it was Homestead at the time of the first transfer. But it was certainly Homestead at the time of the motion.
But at the time the transfer was made, why does that not dictate his client's right to receive a judgment against the estate?
Because there's no case law saying that you go back in time to a prior transfer. There's simply no case law out there that says we go back in time to a prior transfer.
But doesn't Homestead just have to, I mean, the Homestead protection that the Constitution provides us is against taking the actual home, fear that the family will be left with nothing. It's not against taking or asserting a money judgment.
Correct. But it's as to the transfer, or you cannot get a second monetary judgment. I mean, even the case he cites in the Middle District is true. You
Right,
cannot
which
add
is
on.
why let's go back to his case against the estate.
Yes,
Let's pretend that Mrs. Birnbaum was not sued in her individual capacity. It was
Yes.
just the Birnbaum Family Trust.
yes.
Help me understand why this trial judge was not premature in deciding the Homestead issue before determining whether or not fraudulent transfer had occurred for which his client would be entitled to monetary relief.
I think it's as Justice, is it Traver?
Traver.
Traver, I'm sorry.
And not just, definitely not justice, just judge.
Judge Traver. It's as Judge Traver suggested. It all ends up in the same place. It was Ms. Birnbaum's property, and then it went without consideration to the trust, and then went without consideration back to Ms. Birnbaum personally, and was Homestead. So ultimately, the ultimate title to the property cannot be divested. There is no case law out there that goes back and says we're going to divest title from the estate when the estate doesn't have title at the time of the order. It's just that case law doesn't
Why do you need
exist.
to divest title to give a money judgment or hindering his ability to execute?
Because that's what voidability of a transfer means. You have to void the transfer. Effectively, the transfer from Ms. Birnbaum to the estate was mooted. Effectively, it was mooted. The transfer to the estate was mooted when it was transferred back out of the estate to Ms. Birnbaum.
How can you, just on a much more elementary level, and this is kind of the flip side of the question that I asked your colleague. If the trial court erred, but perhaps harmlessly so, by saying Miss Birnbaum's living in the house now. It's her homestead. You're never going to be able to get anything against her because of the Habakkuk case. It seems to me that you're claiming homestead protections on behalf of an entity that does not homestead the house. So the trust does not own the house anymore. Why should the trust be entitled to homestead protections?
It was Ms. Birnbaum who was entitled to homestead protection.
Correct.
And the
Correct.
trust that she put it in, the record shows, is an irrevocable trust, is it not?
It is an irrevocable trust.
So she was never entitled to homestead protection while it was in that trust, correct?
I don't know that that's of evidence. I don't know what the terms of those trusts were.
Well, as a matter of law, if you have an irrevocable trust, you cannot hold homestead property in an irrevocable trust and assert those protections. Is that untrue?
What I would say is because a trust is titled irrevocable doesn't necessarily mean it's an irrevocable trust.
But you would agree that a trust is a separate entity, correct?
Absolutely.
Okay. An irrevocable trust is not a pass-through entity,
It is not.
and it's not a natural person.
It is not.
So just taking 3 giant steps backward, let's assume that it wasn't Miss Birnbaum to the Miss Birnbaum trust. Let's assume it was Miss Birnbaum to me. How would I be entitled to homestead protections in this particular context?
You would not be entitled to homestead protection.
Yeah, so how's the trust?
The trust is not entitled to homestead protections.
So it's a
Birnbaum-
reversal as it relates to the trust, right?
I'm sorry, I didn't.
It's a reversal then as it relates to the trust, because the judgment was entered because of homestead protections against both Miss Birnbaum and the trust. Of those 2 entities, only one of them lives in this house. I think we have clear answers on that. How are you entitled then to assert homestead protections as an affirmative defense against somebody who doesn't live in the house?
The complaint only dealt with the transfer from Ms. Birnbaum to the trust. It didn't deal with anything else. And so it was seeking to reverse that transfer. You can't reverse a transfer that's already been overcome by events. It's a moot point. The trust doesn't own the entity. You can't reverse the transfer to the trust. That's already been, as a matter of fact, reversed.
But counsel, what's the purpose then of section 726.109? 726.109 sub 2 says, except as otherwise provided in this section, to the extent a transfer is voidable in an action by a creditor under 726.108 sub 1A, the creditor may recover judgment for the value of the asset transfer. That only makes sense under a scenario where the creditor is choosing between 2 alternative remedies. It's the transfer is voidable, but it's not actually voided by the creditor, and therefore the creditor gets the money judgment. That's the only way that would make sense with it, because otherwise, are you not suggesting that that would allow the creditor to both get the property and the money judgment?
No, respectfully, Judge White, I think the scenario where that statute applies, and the only case law that I see is not a choice of remedies, but it's where the property transferred is destroyed or no longer recoverable. There's a transfer of property, the transfer is voided, but the underlying property itself is no longer recoverable. It's gone, it's destroyed. That's where a money judgment can be. So, that we transferred the car was crashed and destroyed. There's no car.
I don't know how this particular civil procedural context, though, allows you to make that argument. You moved for summary judgment on an affirmative defense. Effectively, all an affirmative defense does is say, yeah, everything that you're alleging in your fraudulent transfer claims is absolutely true, but it's my homestead. I understand your response to Judge White and in a lesser extent to Judge Nardella to say, no, we can look to the voidability of the transfer. Didn't you concede all of that when you just moved on an affirmative defense?
Did I concede?
You
that
conceded
that was per se voidable?
You conceded his case in chief, didn't you? Like you conceded the notion that yes, this is a fraudulent transfer, but it doesn't matter because it's my homestead. And that circles back to my question. If it's not the trust's homestead, then why was a judgment entered in favor of the trust? Do you see what I'm saying?
I do.
Okay.
And I think theoretically, I understand exactly what you're saying. That does make sense theoretically. Absolutely. And I guess the answer again is the trust at the time that the judgment was entered, the trust did not have the property. But the property still existed and it was protected by homestead in the Birnbaum's name.
Right, but this circles. Go ahead, Judge.
It's somewhat of a circular argument, obviously.
This is not an unusual situation in some ways, correct? Because the statute recognizes that you can have liability not just as a transferee, but a subsequent transferee, and a subsequent transferee. And it just changes the standard by which you can get a subsequent transferee. I mean, the fact that you could have multiple recipients of the property, some of who didn't pay value, and to get a judgment against them, that's not unusual.
I'm not sure what your question is.
No, I'm sorry, go ahead.
Let me ask what your colleague was telling Judge Nardella before about Ms. Birnbaum's individual liability in this particular case. What's your answer to the Davis case, the 11th Circuit decision that you referenced?
Well, what in particular? What?
The notion that this isn't final as it relates to Ms. Birnbaum yet. In other words, if all we're doing at this particular point in time, we're not assessing for collectability in terms of the Homestead defense. I think we can agree that if she stays in that home, nobody's taking it. But what if she moves out of the home between now and when final judgment is entered? Is he allowed to explore his fraudulent transfer claims against her in terms of the fact that it predated her Homestead determination?
In theory, if Homestead were to be relinquished, then that would become a non-exempt asset again, and I think it probably could be pursued. And
How?
I disagree.
He's already, well, I guess it could be pursued in Miami-Dade, no sweat, because there's a separate judgment there.
Yes.
But it's done in Collier. Like, judgment's been entered, you won. So it's not like it can come back from the dead and it be a collectible asset. This case is over unless we reverse it.
Well, perhaps in Collier it is, but there's nothing to preclude. Well, first of all, this case isn't over. I disagree with counsel respectfully on that as well. His motion to amend was still pending. In fact, Judge Hayes appeared on the date of the notice of the hearing on the motion to amend to hear it, and no one showed up to pursue it. So the case as a whole isn't over. He had the ability to pursue other claims that were in his amended plea, proper amended plea. So I don't think this case is over. If he had the ability to file a separate case to pursue the house, I guess in theory, if it were then removed from Homestead and became non-exempt, that would be a possibility. And I don't know how I don't believe there would be a res judicata effect of this case, because that claim couldn't have been brought back then. You can't go, again, it's that same issue. You can't go back in time and argue what happened 3 years ago in a new case when the circumstances are different. I mean, you can't say that it's precluded because the circumstances are entirely different. So I don't know that he couldn't pursue it in a separate action. If he could pursue it in a separate action, I would imagine he could pursue it in this action if this action is not closed. I think that ability exists, but the point is the judge has to enter an order based on the circumstances, the facts and law as it exists at the time of the order. This case had been pending something like 18 months. There was no discovery pending. They had, in March of that year, they had noticed it ready for trial. The motion for summary judgment was filed 3 months later. It was heard something like 5 months later. There was no outstanding discovery on those issues at all. And the court, I believe, rightly decided that under the new rules, counts 1 and 2 were ripe for adjudication, despite the fact that there was a motion pending to allege new and admittedly distinct causes of action regarding other personal property, other things. And so the court decided the issue that was before it, being the transfers under counts 1 and 2, the transfer of the title to the property, and decided that the existence of homestead protection prevented a voiding of the transfer. And then because the transfer was not voidable, monetary relief under subsections 108 was not recoverable because 109 says only in the event that a transfer is found voidable. The court found it was not voidable. So at the time the judge did what he did, he based it on the law and the facts that were presented to him at that time. They were fully developed. There was an argument made after the fact that there was an argument made that there was discovery pending, but none of that discovery related to the title of the property. It related to distinct other transactions that counsel suggests he discovered in outside proceedings in Ohio and Miami, not in Collier County. So it was a very discrete issue before the court. I believe the court ruled on it correct.
If we take Homestead up, what would you say to the estate's attorney who argues that a transferor can be liable for the act, not just a transferee?
A transferor can potentially be liable under the act. Certain provisions under the act that allow a transferor to be liable. And, absent homestead. Just remember, homestead renders the act irrelevant.
I'm going to ask him this as well, but to what extent do we hold somebody to what they pled in a complaint? In other words, the complaint doesn't plead 2 transfers. The complaint pleads 1 transfer. So if we're only looking at the summary judgment being on the operative complaint, why do we get to look at that second transfer at all?
I think you have to by definition look at the second transfer because you have to look at title as it exists at the time.
But I don't know that that's necessarily, and that might be true. I don't necessarily know that that's a great response for you though, is it? Because in that particular situation, his argument that we can then look at liability for Ms. Birnbaum is probably back in play because she's both a transferor and a transferee, right?
But there's no consideration passing. And you can't.
Well, that might mean it's fraudulent.
Well, in that respect, however, again, it's not fraudulent if it's homestead. Again, it's a circular argument. Homestead trumps the act, no matter what. Homestead trumps the act. The fact of the matter is, counsel, he said he was not entitled to double damages, but then he did mention that he gets it on top of the prior. He does not. There's no possibility for the creditor to obtaining money judgment against Ms. Birnbaum. There simply is not, and that's right in Pasternak and Klein. You cannot get an additional money judgment against Ms. Birnbaum, not under any scenario. Certainly not under the act, I should say. I mean, you could if she ran a key down his car, but not under the act. You do not get additional money damages, no matter how many times a quote unquote fraudulent transfer is made. So the only potential monetary liability would be as to the trust in theory. Ms. Birnbaum is absolutely not subject to any monetary damages under the act. Again, Ms. Birnbaum unequivocally and unrebuttedly established that the property was homestead at the time. The court looked at the law, Havaco, Conseco, and found that the act overcame, the homestead protections overcame the act, regardless of how it was cast and how it was pleaded, and it prevented voidability of the transfer. Substantively, I think Judge Traver, you made 2 statements that one of his issues was discovery. Again, if you look carefully, the discovery that was outstanding had nothing to do with the property, had nothing to do with those issues. It had to do with outside distinct transfers that had not been pleaded in this case yet, that were subject to a motion to amend, that had been set for hearing, and for which Judge Hayes appeared on the bench on the date of the notice to hear the motion. So any argument that he was precluded from pursuing it is simply just, it's rebutted by the docket itself.
Wasn't that hearing after the notice of appeal was filed?
It was.
Did the trial court even have jurisdiction to have that hearing?
That would be a circular question as to whether this is a final judgment closing the entire case or an interlocutory order. I do understand. I'm sorry?
What do you say?
I would not dispute Judge Hayes' opinion that he had jurisdiction to hear it. In fact, again, unfortunately, we don't have a transcript. We don't have a transcript, but I mean, at the end, he said, I guess we'll be back to hear if there's anything more to address. I mean, and he did appear.
So you believe the order that you and your colleague are arguing today is a not final order?
No, I believe it's final as the council needs. Does it close the case? I don't believe it closes the case. I didn't believe it then. I believe it closes as the transfer is alleged in council 1 and 2.
So we affirm issue a mandate and we can still amend.
I don't even know that a mandate's required to let him amend. He had a motion to amend pending on the docket and the court showed up to hear it. I don't know that anyone's saying he can't amend. I agree with your earlier statement that there's nothing in the order that says his motion to amend has been denied. It's not implied, it's not expressed, and I don't think it's insignificant that Judge Hayes appeared on the bench to hear it on the date, and I'm not, don't take my word for it. It's in the clerk's notes that's in the docket, that's in the record on appeal. He was there to hear it.
So are you asking us basically, even though maybe we don't need to relinquish jurisdiction to allow the judge to entertain his motion for leave to amend?
I'm not asking you to do it. I don't know that you have to relinquish jurisdiction. I mean, I didn't come ready to argue. I understand the issues you're raising, but I didn't come prepared to argue them. because it just seems to me facially, the trial court believed it could proceed because the trial court did proceed after entry of these two. What I'm saying is that the issues raised in counts 1 and 2 have been disposed of. Those are disposed. He was allowed, he could have pursued his motion to amend. There was nothing preventing the judge was in court to hear it, and he didn't pursue it.
Any question?
All right, well then, at this point, I would close by saying, again, the two issues here, the meat of the case is the homestead protection title to the property. I don't believe there's any law whatsoever that can result in title to the property being divested from Ms. Birnbaum. In some theory down the road, I'm not even going to go to some theory down. The fact of the matter is the case existed today, as the case existed at the time the judge entered the order. It was her homestead. There was no Florida law that allowed her to be divested of that property. Because there was no Florida law to avoid the transfer, at least as to the finding of the judge, there was no basis to enter monetary relief against any party. By definition, against Ms. Birnbaum, she cannot get additional monetary relief against the judgment debtor. And as to the trust, because the court found that the transfer was not voidable, so you do not get the monetary relief under 108 because it's cut off by 109 subsection 2, as stated by Judge White. So we respectfully ask this court affirm the summary final judgment as to counts 1 and 2 in the case. And I thank you for your time.
I have 5 points for the 5 minutes. It was mentioned during the response that no case exists on the double transfer, a first transfer and then a second transfer. In fact, Davis, is exactly not double transfer. The first transfer was to husband and wife, tenants by the entirety, and then they transferred into Homestead. Very similar to the case at issue.
Am I missing that you didn't cite Davis in either your initial or reply briefs? I don't see a cite anywhere.
It is cited by opposing counsel in his
answer.
answer. Yes,
Got it.
yes, Judge.
Okay.
And I cited to Pasternak, which incorporates Davis.
Got it.
We didn't cite, I should have cited it in my initial brief. But speaking of Pasternak, to answer your question, Pasternak expressly states, Florida cases have found that the provision under 726-108, the general provision I was referring to before, any other relief, includes broadly damages against the transferor. I have a couple cases for you if you want the cite, but it is cited within Pasternak. One is McCalla, 2016 from the first. The other one is Hansard Construction from the fourth, 2001.
Counsel, of the cases you just mentioned, do any of those cases specifically permit a money judgment against a transferee who at the time of the transfer to the transferee, the property, the transfer was voidable at that time, but then subsequently the property went on, and at the time of the actual trial or summary judgment, it was now homestead or some protected property?
None of the Florida cases have those facts. Both the federal cases have exactly those facts. And they say, yes, you can.
That's Davis and Pasternak.
Yes. To answer your question, Judge Praver, on, and credit goes to Angelique Gula, who couldn't be here today, but she's watching and she sent it to me. The final judgment mentions the motion for leave to amend. It's in paragraph 7 of the final judgment. So there's ample record evidence that it was brought to the court's attention. And all the court stated was, it doesn't
Change your theory, yeah, but there's no order denying.
but it certainly was brought to the court's attention. To your point before, that by being in the docket, they don't know about it. The fact that it was mentioned in the order shows to this court that it was raised and the court was aware, and the court decided that notwithstanding the motion for leave to amend, the final judgment it entered was final, because we are here on appeal on a final order. The order says count 1 and count 2 are gone. My client recovers nothing from the defendant And that's why we're here.
Is
Well,
there
I'm-
any reason though why you didn't go and ask that should it be? Well,
Well, number one, I disagree with my friend, Mr. Bonner, that it was heard. In fact, there is a docket entry before that says canceled. The hearing on January 24 at 9:30, canceled.
my question's a little bit different. Be that as it may on that particular day. Is there any reason why you just didn't go get an order denying it or granting it as the case may be? If it got
I
granted,
didn't believe the lower court had jurisdiction. The lower court had concluded the case with entering the final judgment. I filed for a hearing before final judgment was entered. I said, well, there's a motion and there's a question of money judgment, denied without a hearing. Then the order is entered on the summary judgment saying you go without a day. I file an appeal. And then there's no longer jurisdiction for the lower court to deal with the issue. That's the reason why I didn't believe I was allowed to do anything else at that point. And the only motion I had filed was denied without a hearing. And then the final judgment was entered.
But the provision of the trial court's order that addresses that issue quoted. Says accordingly, the pending motion to amend. So would you agree that by using the term pending, that means the court has not ruled on?
The court may believe that the trial court has not ruled on. But the law is that once you enter a final judgment saying that there is nothing left in the case, that the counts are disposed of, and you don't reserve leave to amend, then you have in fact entered a final order, leaving no further judicial labor and not allowing me to argue any of that.
Thank you, counsel.
Thank you.
I'm sorry. Thank you, counsel. That will conclude. Our next case on the docket today is Universal Property and Casualty Insurance Company. Rebecca Hughes versus Universal Property Casualty Insurance Company. It's going to be case number 23-296. I would remind the parties that it's also being live streamed. Each side will have 20 minutes per side. We have automatically reserved, I can do this correctly. There we go. All right, there we go. We have fixed the timer. We've automatically reserved 5 minutes, but we can increase that time or decrease. Counsel, when you're ready.
Yes, Your Honor. Good morning, may it please the court. I'm Tom Elliott here on behalf of Rebecca Hughes. Ms. Hughes' insurance policy was issued in 2019, and her loss was in 2019, her property loss. Over 2 years before Section 627.70152 was adopted. 627.70152 imposes new requirements on insureds and restricts attorney's fees. These are substantive changes. The Menendez, Supreme Court Menendez, page 878, says we have previously held that the statutory right to attorney's fees is not a procedural right, but rather a substantive right. And then we have the Supreme Court later in the Florida Insurance Guarantee versus V-bonds, page 14 of our initial brief, saying there must be a clearly expressed legislative intent for retroactive application, and that the absence of the statement that the amendments do not apply to an existing contract is not clear evidence of retroactive intent. Here, there is no retroactive language. We have a July 1 effective date, just like we did in the Zuckerman case cited at page 13 of our initial brief. The statute of Menendez had other language, that the pre-suit requirement there applied to all actions filed on or after the effective date. We talk about that at page 14 of our initial brief. That's what clear language looks like. That also made it unconstitutional because it was applying to policies that were issued before that effective date. And that's probably why the legislature did not make 70152 retroactive. It is like the difference in the supplemental authority we just filed on this new House Bill 837 that's now in law. You have two sections there. You have a section 30 effective date that applies to actions filed on or after that date. Tort, because that statute has tort provisions. But then section 29 says, oh no, for insurance, it's for policies issued or renewed after the effective date. I would suggest this shows the legislature has a better understanding of how to constitutionally amend a statute than Universal does. Universal's claim of retroactive language here is simply like the emperor's clothes. It's just not there. There is no such language in the statute. Universal wants to rewrite the statute. But the Florida Supreme Court opinions say we don't do that. They also say we follow the plain and clear text of the statute. We have a clear effective date.
Let me ask you just as it relates, and I know what you're going to say, but just specifically, Hugh, to my question, as it relates to just that notice provision, just the idea that you have to give somebody 10, and not just the other party, the department, you have to give the state 10 days notice before you file a lawsuit. How is that substantive?
It imposes an additional burden on the insured. Menendez says when you have to give notice, that is a burden. That is substantive. Okay. Now,
So any burden is always substantive.
no, Your Honor, no. But to go where I think Judge Traver was going, you look at the statute as a whole. Section 3 says you give notice.
I want to go back before you get to that, because I knew that was what your answer was going to be.
Okay.
But looking at that sentence in a vacuum, what you just said, I think, is because it imposes some type of a burden, therefore, it is substantive. And that's it. Even though it's 10 days, just because it wasn't there before.
It's not just 10 days. It is 10 days and file all this junk. Prepare and get together all this stuff you have to do. And there's a list, estimate of damages, itemize the damages. There's a whole list of things you have to do. So it's not just, hey, we want to sue. It's we want to sue, and here's our package of material we had to put together. Okay. If that were all it said, and it didn't penalize the insured for not doing that by dismissing their suit, and it didn't penalize the insured by denying them fees, that would be a different discussion. But here, again, we go all together. Section 3 just says file the notice. We're not here because of Section 3 alone. We're here because Section 5 says if you don't file the notice, you get dismissed. And then Section 8 says if you get dismissed, you don't get fees.
Do we care at all on the fact that the legislature has completely junked the fee provision in subsequent statutes?
For our case, no. Because, again, Section 29 in the new bill, which completely jumps it, to use your words, says it does not apply. It only applies to policies issued or renewed after March 23, 2023, whatever the date is, 23. So 627.428 is still in effect for this policy. It's in effect with maybe some modifications that are academic to our case, because our case predates 2021. Maybe there's something, I know they filed supplemental authority of the 2022 December change that tinkered with it, took out some parts, maybe for policies after that.
Took out subsection 8 in its entirety.
Yes. And for
The attorney fees, penalty provision.
Yes, for cases arising under policies issued or renewed after July 1, 2021. So you've got a period in there from July 1, 2021 through December 2022 that something else may happen. That's not our case. It might be an interesting academic exercise to try to figure out what's going to go on with those, but that's not our case at all. We're under 627.428 pre-July 1, 2021.
What, if any, policy rights that your clients had were affected by the statutory?
Thank you, Your Honor. As we've said in the brief, and as the case law makes very clear, the right to attorney's fees is made a part of every policy. So they had a right at the time, and let's think about that for a minute. Let me go a little further. At the time she bought her policy in 2019, she knew the 627 or whether she knew it or not, the 627.428 fee provision was part of that policy. Okay. She paid a premium. Universal charged her a premium based on knowing that it would have to deal with that fee possibility under 627.428. So if we take that away from her by a 2021 change that's after her policy and after her loss, she has been penalized. She's been overcharged for that policy, and Universal gets a windfall. They get a windfall because now they're going to have less coverage, if you will, less because, again.
Counsel, where in the trial court's order does the trial court make any of those rules? Where does the trial court say, in any respect, that your client's right to attorney's fees is being addressed, being ruled upon? Either hypothetically in the future, at the time of this order?
Your Honor, the order simply dismisses the case.
Without prejudice.
Without prejudice and without leave to amend. Okay, so you got to file a new case. So what happens then?
By the way?
Pardon?
Have you filed a new case?
No, because we're still within the statute of limitations. So if this court were to reverse, which we certainly hope will happen, this case will be reinstated and will be a need to file a new one. If she has to file a new one, there's another filing fee, and she doesn't get any fees for the time before that, where under, as we cited the case law and the statute recognizes, you would have gotten fees up, from the beginning of the case going forward and actually pre-suit fees.
But where's the court order? Where's the trial court's order state that she's ruling that your client will not get pre-suit fees?
Your Honor, that's by operation of if this statute applies, that's by operation of the statute, because the statute in section 8 says you don't get fees.
So if section 8 is applied retroactively, that would affect your client's substantive right. If a trial court rejected the argument that I would assume you would make at that hearing would be.
Your Honor, I'm not sure I'm following the question, because 3 takes you to 5, which is the dismissal. And if you're dismissed under 5, you get no fees under 8 by virtue of 8.
I guess my question is, has the trial court entered any ruling denying to any extent a request that your client made for attorney?
I think the dismissal of the case is effectively that denial. I don't think the order says, and you're not getting fees, but that's what happens by operation of law when your case is dismissed.
Would the trial court be able to rule any other way?
Pardon?
Would the trial court be able to rule any other way if that question is presented?
We went back now and asked for a fee. I suspect we'd be greeted with laughter and a denial.
But couldn't you argue that subsection 8 cannot be applied retroactively, and so therefore the court should grant your client's request for fees, assuming you prevail below in the new lawsuit?
Your Honor, I think that by virtue of the operation of the statute, I'm sure we would hear that's been decided. That's res judicata or collateral estoppel, because by operation of law, you're not getting any fees for that earlier time.
How would it be res judicata?
It's the same parties. It's been decided. Are you saying if you reverse and you say, we're going to reverse section 8, but we're not?
Let's assume if we were to per curiam affirm the dismissal, which on its face state was solely based on subsection 3, how would that in any way collaterally stop you, have a res judicata effect or any preclusive effect?
I'm sure we'd hear that argument, Your Honor. Because the statute operates together. You read the whole statute together. And they're going to say, when you got dismissed because you didn't do the notice, that precluded you getting fees under section 8. I mean, if you're asking, could you craft an opinion that says, we think the notice is okay, but you can't, you can't dismiss it. You can hold it in abeyance or something, and you can, and they're still entitled to fees, even file a new action. If you wrote an opinion that said that, I guess we could take a run at it, but I think that's a long way around when this is clearly has no retroactive language in it. I mean, that doesn't even get you to applying the notice part, because the notice part before, at the time of the policy, time of the loss, there was no delay. There was a vested right in the policy. What do you call it, a vested right? You had a right to institute cause of action. There was no burden or delay from the notice. And the Spiewak case says you can't impacted. There is a burden of notice. And again, the documents I talked about. I mean, this is a situation where once you look at this and say, there's no retroactive language for the statute, we don't go then and start picking out pieces and say, well, we'll apply this one retroactively and not that one. There's no retroactive language. It's not applied retroactive, period. Period. Now, I think I've covered with that and with your help in the questions, the main points I want to cover. There's a lot of other stuff in the briefs. We address a lot of other points. I'm happy to rely on those, but if there are any more questions, I'm happy to answer those. Try to answer them. In that case, we'd ask that you reverse because there is no clear retroactive language and the statute applies to policies issued only after.
Well, I suppose I should ask you about the waiver argument.
Okay.
So in that particular context, why don't you just give us the 20-second thumbnail view of the waiver argument?
Okay. As your question suggests, it's not necessary if you rule this on point one. There are no disputed facts. I understand there's some case law that says, well, waiver, that's a question of court discretion. There are no disputed facts here, so there's really no discretion. It's a question. You look at this and you say, was there a waiver or wasn't there? Universal engaged in merits discovery before it moved to dismiss.
So when we look at, and I think that thumbnails it.
Well,
because they were asking, and you look at their requests for production and their interrogatories, and they're asking the things that insurers typically ask. How much have you been damaged? Provide some documents showing that you've been damaged. How is that acting inconsistently with asking you also to file a notice that outlines what your damages are?
Your Honor, we've cited the case law. There's no requirement of prejudice for a waiver.
Right.
We don't have to have been damaged. They didn't need that. They don't need any discovery. They're going to come in and say, hey, you filed after July 1. You have to give notice. End of discussion. They need no discovery for that. None. Zero.
Typically, where that arises from is the arbitration context, the prejudice issue.
Yep.
And I'm wondering if you view a difference between the situation that we're currently in, where nobody disputes that this matter is going to go forward in this lawsuit or a subsequently filed one on the same policy, versus a situation where somebody's saying, I don't even want to be in a courtroom at all. I should be in front of an arbitral panel. So in other words, that concept, do you follow me? What's inconsistent with them asking for a notice, and not just a notice to be filed to you or to somebody else in the case, but to the state, which is the other aspect where I'm struggling with the waiver.
Well, Your Honor, and again, I hope we don't get to waiver.
Fair.
But let me say this. The background of this case is the claim was made in 2019. She sent materials. Universal made what it called final building and contents payments. It made payments, so it acknowledges loss. She said, I disagree. Universal says, send some bids. She sent the bids. And then you know what happened? Nothing. No response at all. And this goes on, and then she sues. So they had the information. So again, we would ask that you reverse. Thank you.
May it please the court, Dinah Stein on behalf of Universal Property and Casualty Insurance. And this case is about notice. It's about nothing other than notice. It's always been about notice. To the extent, plaintiff has argued all along, hypothetically, what if with fees? We've never asked for fees. You'll note that we did not even move for appellate fees. We're not taking any position on fees. This is only about notice. And if fees wasn't already moved before the end of 2022, it certainly is now, because again, as we noticed in our notice of supplemental authority, fees aren't even in the statute anymore. It's just a non-issue. What plaintiff wants this court to do.
Let me ask just on that subject. If the insureds do what you're asking for them to do, which is to basically refile in a different action, and then they're successful in that action, are they entitled to their pre-notice fees?
If assuming things have been preserved, I mean, I don't take a position, there could be a rule 1.525 problem with the last case, but I think we'd be hard pressed to take an issue on fees that's retroactive. Because, I mean, our cases in the brief essentially concede these are substantive. So I think whatever applied, then I'd have a very difficult argument to make that somehow fees would be retroactive as well. We're just talking about notice. And what the insured wants the court to do is just blind application of Menendez. Menendez talks about PIP. We're both insurance.
To me, I think that that's a wonderful argument, in the sense that PIP is its own animal. The idea here is that when that PIP statute was amended to require pre-suit notice, those insureds were being absolutely deprived of fast payment. That isn't the case in a property insurance context. But what I want to ask you about is something that's only dealt with very cursorily in your answer brief, which is the Devon case. So Devon, if I'm looking at it, seems to suggest that Menendez test applies to all insurance policies. Certainly in Devon, it's an association, it's a commercial residential policy. But it doesn't seem to me that in that case, your arguments about PIP being its own animal, which otherwise I would be all over, seem to apply. Could you just comment on the effect of Devon for me and how we look at that?
Well, so to take the plaintiff's position, I mean, in any case, because, the cases, are a little bit all over the place as far as applying Menendez. But we have to ignore essentially a page and a half of the Menendez case. I mean, the Menendez court laid out the analysis, and that is in order to even get to the retroactivity analysis, we need to look at the nature of the statute.
But the Florida Supreme Court actually just doing it in a property insurance setting, can't we just assume that they, in that case, looked at the statutory scheme? Or maybe that they forgot, although I would note it was the same composition and was also unanimous. So I'm not really sure that if, for example, like Justice Kennedy and Justice Polston really had no problems dissenting if they thought that a step was missed. But they went right to that Menendez and they said, we've got to look at Menendez in this particular context.
And as the Adams court said, and this is going back now to 1981, for each time you do this, you're looking at the nature of the problem before you.
What's the difference between the nature of the problem before us in Devon and here?
The difference is, this is a pure, first of all, we've got a remedial situation where, and we've gone through the legislative history, this was to cure a very significant problem in Florida. I mean, Florida has 70-something% of the property litigation in the United States with 8% of the claims. So I don't think we can get past the remedial aspect of the 2021 legislation and what it's intending to cure. And this notice provision is really just to prevent this race to the courthouse and try to resolve these things so they're not just, the machinery of the attorneys taking over when things can be resolved. So, I think that's a difference here in that this was trying to correct an immediate problem. And Your Honor, I can't tell if you're going to ask a question. Okay, I didn't want to speak over you. This.
Other than that, anything other than the legislative historical intent, what's the difference?
Well, the difference, I'm just going to grab Devin to. I don't see it. It must be a different first name of the case.
Oh yeah, it's FIGA. It's Florida. It's FIGA versus Devon Neighborhood Association. You've got it cited in your answer brief, but only briefly to say that it's not relevant.
The notice of mediation.
Right.
So this is where the statutory amendment basically required notice of mediation as a condition precedent to the right to invoke appraisal. The neighborhood association said, I don't have to participate in appraisal because the subsequent statutory amendment said They need to give me notice of mediation, which is, you see in all the policies now at the beginning and big, presumably because of this case, or that statute. And FIGA's predecessor, which had gone insolvent, didn't give that.
Right. It's still a different statutory right. I mean, the mediation appraisal, we're now getting into perhaps duties and a timing that wasn't involved here. I mean, here it's really literally just a notice to the department that puts the insured on notice and allows it, the insurance company on notice.
Well, I mean, all that was at play in Devon was a notice to the other side that we could give you mediation. Seems really harmless in the sense that it's not really a obligation to collect documents. It's not an obligation to liquidate your claim to a specific dollar amount. It's not even an obligation to participate in mediation. It's just that, hey, it's available if you want it.
Well, another argument I'm going to make in that respect is, we don't know from the opinion, as I recall, exactly what was argued in Menendez, in Devon on the insurer's behalf. Plaintiff here says we should just concede error because others have, I don't agree.
The insurer basically said that the lower court, because it only looked at constitutional implications and it didn't look at the plain language of the statutory amendment to see if there was intent for retroactive application. So let me ask you, where's the intent for retroactive application in this particular?
Sure.
statute?
Well, so the language is clear in the sense that it says it shall apply to all, actions after this date.
But that's about lawsuits. It's the retroactive intent as a standing policy.
So the statutory provision, the act had a lot of different provisions, some substantive, some procedural. When the legislature does that, that's legislative language for, if it's procedural, it applies now. That's just the default. And if it's substantive, it does not. It couldn't have had specific language to this act because a lot of it was very substantive. So, counsel points out that they did it in the most recent act. Sometimes the legislature puts specific retroactivity language and sometimes it doesn't. It doesn't need to for procedural. That just goes into effect and the language is superfluous. And we know from the legislative history that the original intent, at least in the House, was to have this only apply prospectively, and then that got removed from the statute. I think that just demonstrates that the legislature knew procedural immediately goes into effect, as always, as the default.
Counsel, can you talk, I know you touched on it in your brief about the single cases, but can you talk about how we analyze the statute and parse it out? It's your position that certain provisions can be substantive and certain provisions can be remedial instead of taking the statute as a whole and giving it one label. Can you tell us the basis for that argument?
Sure. Well, that's exactly what was done in the sinkhole cases that, for instance, citizens in that the plaintiff, the insured said, look, this legislation, some of this had these provisions, some of it was substantive. The second district parsed it out and said, all right, if we're talking substantive, like the definition of structural damage, that's going to be prospective only because, that's taking away rights and modifying rights under the contract. A stay pending mediation is procedural. That's just the machinery that allows the case to go forward. It's not impacting any rights. And therefore we can apply the stay retroactively, but not the rest. I think it's exactly on point. And it shows that, this is just such a different animal than, for instance, PIP and all of these other provisions that have been dealt with substantively. The test is you have to put in, what is this hurting a right to? It affects the right. I mean, that's what, the right to attorney's fees, the right to subrogation. Well, if you say the right to not have to file a notice with the department, it's pretty awkward. I mean, what right is that? Where is that in the insurance contract where you
Well, there wouldn't be because the department isn't a party to the insurance contract. So let me ask the same question that I asked your colleague. What policy rights were affected by this statute?
Zero in the application to this case. There was not a single policy right affected by the statute.
Is that another way that we can distinguish Menendez and Devon? which is basically that both of those work some change to pre-existing policy rights?
Absolutely, absolutely. I mean, you know, Menendez is so clear that you just have to look at the entire statutory, well, your honor has already essentially said it, you know, that when the legislature abrogates the common law and replaces it with this machinery hip, which is, you know,
Devin's my
Right.
bigger concern. So Devin basically says you've got a situation where there's a subsequent statutory amendment that engrafts this requirement to notify the opposing side of mediation, the insureds. It's because the insureds wouldn't have the obligation to notify the insured. So it's a one-way obligation to notify the insureds that mediation is a possibility. How does that affect their policy rights? Maybe that's a better question for your colleague, but I'll ask it to you.
well, I do think it affects policy rights when you're dealing now with the notice of mediation and arbitration, appraisal, things that are in the policy. That is an impact on the policy rights. And just on your basic two-part analysis, when you deal with insurance policies, once you start impacting anything under the policy, a right, I think
So
that's.
in Devon counsel, was there actually a provision in the 2004 policy that dealt with appraisal? That was actually a contractual provision in the contract itself.
Offhand, I don't recall. I don't recall if that was stated in the opinion, but certainly I know a lot of the policies do have language with appraisal. I mean, that's certainly a standard property insurance language, but I don't want to guess. I'm not sure. But you know, again, it's just a different provision, and you know whether the or the insurance company argued, you know, that. I mean, it didn't seem like it was a very thorough analysis in the opinion, just kind of like a application of Menendez. But I certainly think it's different. We just don't have the remedial aspect that was discussed in the FIGA opinion, the Devon opinion. And, you know, here, I think it's very significant that the legislature was trying to make some significant changes to aspects of property insurance, given what the task force found. I mean, I don't know that we can ignore the entire task force findings, and what they found was just an unsustainable situation in Florida for insurance companies. That's what it was trying to correct here. That's a difference in Devon as well.
What allows us to look at legislative history in this case in light of the Amendment 4 decision talking about the supremacy of the text? Is there something about retroactivity analysis that's just inherently different? And if so, where does that come from?
There's still the third prong of the retroactivity test, which is this remedial? And I don't know that that's been abrogated. And so, you know, whether we look at supremacy of text, you know, if we look at supremacy of text, then I think we would just apply this. I mean, the legislature said this goes into effect now, and it goes into effect. But we always have this test is, are we taking away a vested right? So I don't know if supremacy of text really changes the result here. If anything, it probably helps the insurance company, because then you just apply the text of the statute and we're done. I think the retroactivity analysis still applies because we've got a due process right to vested rights. You can't retroactively take them away. And I believe that just, you know, it takes us back to, is it substantive, remedial, or procedural? And I would submit, as we do in the brief, it's both procedural and remedial, in that it's trying to fix an unsustainable condition. In fact, it's still trying to fix this unsustainable condition, but certainly in 2021, the legislature felt that immediate action was needed, given the crisis with homeowners insurance. So I don't know that changes anything. But you know, going back to just, certainly not a Menendez situation. I don't think this is a FIGA situation. This is just a common law property insurance case. The cases have all recognized that those, unlike PIP and other procedures, just go off on their own. And we're just talking about a notice here filed with the department. It's not even some kind of an appraisal. It's not notice of mediation. It's just a notice that goes to the department and puts the carrier on notice. If the notice provision was carried out and the plaintiff disagreed with whatever the carrier came back with, what would happen? The exact same thing that would have happened without the notice requirement. It just tries to stop the races to the courthouse, but it doesn't take a single right away from the plaintiff under the policy. Now, I just very briefly, and of course, if your honors continue to have questions on the substance, I'm here. But the waiver, I just wanted to say it's a pure abuse of discretion. I mean, there's not a case out there that finds that you can waive this type of analysis, and the arbitration cases have absolutely nothing to do with this. This is absolutely nothing inconsistent about filing a discovery, filing 2 days before the motion to dismiss. But I'll go back to just the nuts and bolts of this. This is not about attorney's fees. It's not about taking away rights under the contract. It is literally about, do we take away rights by requiring insureds to file a notice? I think it's really a very easy answer. The answer is no. The contract doesn't change rights. They could go back and file this and end up in the same exact position. But with that, I would ask the court to affirm the decision below, unless your honors have additional questions. Thank you.
Going to speak to why I think there's no retroactive intent, and that applies to the entire statute. But so that it doesn't get lost, let me say that if the panel were to say, well, we're going to just carve out and look at section 3 just by itself and find that's okay, I would request that there be a written opinion. And that opinion include the concession of Universal that Ms. Hughes would be entitled, if she ultimately prevailed, to get fees for this first case, for her first action. Because they conceded that before you 10 minutes ago. And that would need to be in the opinion. I mean, I guess we can try to order up the tape and show it to the trial judge. But I think it's much better, with all due respect, if it said, we're only looking at 3, but that's
Does that concession resolve this case?
I'm sorry, what?
Does the concession resolve the case?
No, I don't think so, Your
Why
Honor.
not?
Well, because again, we talked
Have you been
about,
substantively affected at this particular point if you know you're going to have to refile this thing anyway? There's an affirmance. So you know you're going to have to, we affirm, you know you're going to have to refile it with a notice, and you know what your damages are. So in that sense, I don't necessarily know that I ascribe to the idea that this is some huge big rigmarole to notify the department.
there'll be another $400 or whatever filing fee.
Okay, and that's not nothing. I'm not.
It's a damage.
Yeah.
It's a damage, and that's why if we prevail, we're the prevailing party on appeal. If we save $400, or if we get a new decision on that.
Other than your filing fee,
Your Honor, there
because
are
you're within the statute of limitation, right?
Pardon?
You're within the statute of limitation on a 2019 claim.
Yes.
Yeah. So what's with that concession, other than your filing fee, what's the damage?
It requires it does require the additional information, which, as I said before, she sent the estimates they asked for, and they did nothing. They stopped communicating with her. Why should they have another chance at that? Why should we go forward with that? I mean, what happens if they send a notice and she sends a notice, and now, having seen what happened here, they go, oh, okay, now we're going to pay some more. I think we need something that would say, well, then she gets her fees for the first action because that's what led to this.
Well, I mean, they've conceded that you're gonna get your fees for the pre-suit aspect. Maybe you don't get, I don't know. I mean, who knows what the trial court's gonna do, but she's conceded that fees are substantive. And frankly, it's hard to disagree reading this whole host of cases that you guys have put in front of us that fees are procedural.
Okay. The,
Counsel, let me ask you this, in terms of this burden that you mentioned, following up on Judge Craver's question. Is any legislature does with respect to something involving some kind of burden to file a suit, is it always going to be substantive or does it depend? Is it a de minimis cost? Is it a certain number? For example, could the legislature require that all litigants go to pre-suit mediation before filing any civil action in the state of Florida? Legislature do that, or would every person who had a cause of action that be a burden that affects their substantive vested right, even though they haven't filed suit, but let's say they have an approved cause of action?
I think I'd want to think more about that, but saying you can go to mediation, assuming the statutes of limitations are told, there's, and you're going to go to have that mediation step, that strikes me as the type of a sort of a lesser med mal pre-suit filing process.
But that could be costly.
Yeah, and that case went through a lot of ramifications, and the court said, yes, you can have med mal pre-suit, but they didn't make it retroactive.
But how could it be for suits that haven't been filed yet? I guess this is where I'm really struggling, is that in terms of just my first question, looking at this sentence in a vacuum, like if a suit hasn't been filed yet, a suit hasn't been filed. To Judge White's question, I think there might be a difference if the legislature said every case before it's filed has to have pre-suit mediation, and then all of a sudden a defendant moved to dismiss for a case that had been filed beforehand. Like that wouldn't have retroactive application. But this particular provision in 3, all it says is give 10 days notice to the department. And by the way, to your point just now, all the statutes are told in terms of statutes limitation as it relates to.
Actually, let me say two things.
Yeah.
First off, as we say at page 20 of our initial brief, Menendez, Borden, they say you don't just look at one section. You have to read the statute together. Have to read it together. Supreme Court, unanimous, as you pointed out, have to read it together. And when you read it together, this does not survive the analysis they want.
But didn't they read it together? Because that's what the 3rd district had done. And that was the posture it came to the Florida Supreme Court.
Well,
The 3rd district had ruled that the entire subsection 11, which contained multiple subsections, that entirety was procedural. And the Supreme Court clearly said as a whole, it's substantive and reversed.
And again, we look at this as a whole. When you're taking
But
away.
that's not what our trial judge has done.
No, well, it's. But for the concession we heard for the first time 20 minutes ago, that's what would have happened here. It would have been, it's all together. I still think you look at it all together. But
the piece of the reason here, right?
no,
Because the jeopardy before that concession, the jeopardy of having your case dismissed is potentially 2. One is you lose the fees, right? The second is maybe you're outside the statute of limitation and your claim is purchased.
and your filing fee.
Well, you said the final.
Right, but yes, yeah.
But I don't necessarily know that maybe you would have taken this appeal over the $400.
Your Honor, let me, because I know I'm getting low on time. You said, well, with the notice, you can tend to, this is more than I can do in 49 seconds. But if you look at 701.523A, the notice of intent, 10 days, and then it takes you to 701.31. When you read through those statutes, maybe I'm missing it, but there's Part B says it tolls 95.11 time limit for 10 days, but it doesn't say you get tolling after the insured responds, and they get 90 days to respond under 701.31. I mean, it is, look at the tolling provision there, and it is complicated. And I think there is a real danger that it could be construed to, while this thing is sitting there, for the insurance company to look at it. Let's see which section. Well, it's section 3A, and then you read that with 3B. That while the insurance company's looking at it, the statute runs. And you've got your 10 days, you're past that. I mean, there is a real danger here.
Thank you, counsel.
Thank you.
For your time. I want to thank you both. This was well brief, well argued. Thank you. Court is now closed. Our session is closed, but we wanted to invite the students if they had any questions and wanted to hang around for a little bit. We would love to speak with you.
What are you guys here for?
I'm going to be right back. Take it.
We're gonna take a read. Somebody just left. No, is this for a class credit? Yes, ma'am. Kristen, we go off the record. Sorry,